Rosa and I are very excited to be here with you today to talk more about who's on the hook, right? That's what we're doing in this series because while we're all litigating our cases, there's so much more that we have to be knowledgeable about to properly represent our clients, whether they're the plaintiffs or the defendants or the carriers that we all represent on a regular basis. There are insurance issues that can create, problems or create confusion or create hurdles. But at the end of the day, there's always an answer, right? There's always an answer as to where to go, what to do. And that's why Rose and I are here in the series and today to try and help. And as always, I think most of you have attended CLEs with me and with us before, but a couple sort of ground rules. First of all, we love questions. So there's a Q&A. Pop your questions in. If we can, we'll take them during the presentation, the first hour. But if not, we'll address all questions from 2 to 2:30, the last half hour of the program or the additional half hour of the program. And you also will get additional credit if you hang in here for the half hour in addition to the first hour. Also, as Michelle said, if you have any questions that are not answered or want to speak with me or Rosa, Michelle's going to post a one-on-one Zoom link. We do that as a courtesy to the profession, 30 minutes, 15 minutes, whatever you need. We're happy to chat with you anytime. You could also scan our codes here. That'll bring you to our scheduling. And I have my podcast links, books, all that sort of stuff. These CLEs do go onto the Mentor ESQ podcast if you like to listen by audio. Some of you are listening to this now by audio. And if you go to the mentoresq.com and click through, there's actually these videos so you can see it. I just released a podcast episode last week with my good friend Torsten Gross, who's a quadriplegic race car driver, amongst other things. And it was really exciting. So I encourage you all to check that out if you haven't already. All right, got all that out of the way. Let's talk premises liability. It's a phrase we all throw around within the industry, and it's basically when there's litigation that occurs as a result of an accident on someone's property, otherwise known as their premises. So when someone gets injured on someone's property, the question then becomes, who's responsible, if anyone? Who are the potential tortfeasors? And whose coverage, whose insurance policies are going to come into play? And are there insurance policies and or tortfeasors you may not even think about that you should be thinking about? Could it be that you have a good case sitting there, but you have no idea that it was one that you can get money on for an injured client? So that's what we're going to talk about today. I'm going to kick it off and talk about sort of the litigation issues. And then Rosa, our insurance coverage guru, she's going to let us all know about how you navigate these areas and what the insurance issues are in these areas. So basically, when you're looking at a premise liability case, it's anybody's property where there's an injury. And this can happen. We often see the classics trip and falls or slip and falls in a lobby of a building or on a sidewalk in front of a property. Those are sort of the classic cases you think about when you have premise liability. But construction site accidents, Labor Law 200, if you don't know what I'm talking about, check out our prior CLEs or look it up. They're there. But that's common law negligence for a property owner failing to keep their property in a safe condition for people on their property. It could be in a gym setting. Someone's working out and they get injured because the weights fall on them and they shouldn't have fallen because the machine that they're doing the pull downs on wasn't properly maintained. That's someone who's not keeping their premises in a safe condition. Someone gets injured in a family member's house. Can they sue their family member? Are they barred from it? What's the story there? So what if somebody falls on a sidewalk right in front of a store? Who's responsible? Is it the store? Is it the building owner that the store rents from? Is it both? Is it the city? Is it a city sidewalk? So these are all the things that as lawyers, we need to identify. Sometimes it's easy to identify early on, even pre-litigation. Sometimes it's not. You got to get underway. You got to do a little more digging, maybe even before you file suit to name the proper parties. So basically, when you're working up these cases, you have to first do the analysis of potential tortfeasors and explore them all. Then you look into who's got the coverage and explore that all. And if you're on the defense side, you always want to look at the risk transfer. So you want to be like, hey, I'm the building owner. I just got sued, but wait a second. I have a contract with the tenant to indemnify us, and they're in charge of maintenance, right? So you need to be able to look at all these areas, whether you're plaintiff side or defense side. All right. And obviously, in any property or premise liability case, you're either going to have to prove constructive notice or actual notice or written notice if it's the city. And by that is, if someone gets injured on somebody else's property, you can't hold somebody responsible for that unless they knew there was a problem on their property, right? They had some type of notice. And so a plaintiff has to establish that they either knew about it. So constructive notice is if they walk into their building every single day and there's a huge crack they walk by, and you could establish that discovery. Oh, and you walked by it every day and it was there. That's constructive notice. Actual notice is someone sending a letter or calling them up saying, hey, you've got a problem. You need to fix this. Written notice is someone writing a letter or a notice of claim or a complaint or an email or something that's put down into writing. So you need to prove notice or that they created the condition. That's the way you get around notice in a property or premise liability case. If they created it, if they put in a new door at the entrance to their building, but they didn't do it properly and they left a huge thing sticking out, jutting out that caused an injury, the argument is they created that. All right. So you have to have either notice somehow or prove that they created it. And how do you establish all of this in litigation? Well, like any other case, you got to work it up, get your investigators, look for video, get your engineers out there, get photographs, get measurements, because a lot of premise liability defects may be cured. There may be a crack that gets filled. There may be transitory, maybe a hose was coming out that they were doing some cleaning and someone tripped on the hose. So you want to make sure you try and get videos, photos. You want to do a search of notice. There's different ways you can do that. You can do FOIL requests. You can go online in the on the court systems and type in the potential defendant's name, see if there are other cases, sometimes the same defect. I'll never forget about 20 years ago, our good friend John Afridi, some of you may know, he went out to photograph a situation where like a post broke off and left like a stump on the ground that somebody tripped over and fell. And we sent him out to photograph it, and he called me up. He says, you'll never believe this. Another law firm a year and a half ago had me come out and photograph this. So I know there's another case. He gave me their name and they'd filed a complaint. And so we got our notice that way. So there's lots of ways to do that. You're going to look at statements in the plaintiff's records. What did they say was the cause of their fall? Did they say they tripped on a defect, or did they say, I lost my balance and I wasn't paying attention to where I was going? So both sides need to look at all the medical records. Do your homework on these cases, and then you will narrow it down to determine who is the responsible party and who's carrier. So you're going to need to identify owners, tenants. You may need to pull up deeds from the records for the town or the location where the premise is. Super important. You need to find out if a municipality is involved so you don't blow notice of claims. So you need to do your homework. Then once you're ready to rock and roll, then you say, all right, where's their coverage? Is there coverage? And that's where sometimes it gets a little messy. And that's why we're fortunate that we all have Rosa to go to and we ask her, what do you do? So with that, Rosa, why don't you jump in now and let everybody know about what issues coverage-wise you often see come up, what issues we need to think about, and how to address and handle all of these.
All right, great. Thanks, Andrew. And thanks, everybody. It's good to see everyone at the end of December of 2024, right? Almost into the new year. So just as with the liability aspects of the case where you have to figure out the parties, the location, and the type of accident, those things are going to affect what coverage applies, right? So as Andrew said, there was in the construction context, that is a premises liability case. And we did an entire CLE last month on it, and you can go onto the Academy website and see that CLE. And as part of that, we talked about how construction accident cases, as opposed to just general premises liability cases, are slightly different in the sense that the construction accident cases have the labor laws that govern what's going to happen to the parties or the liability of the parties, right? So when you're looking at construction accident cases, it's a labor law 240 or 241.6, and that imposes a non-delegable duty upon the owner and the general contractor, but to provide a safe place for workers, right? So if you can prove that, then you have that statutory liability and they're responsible regardless of whether they're negligent or not. But if you don't have the elements of a 240 or 241.6 case, now you're relying upon Labor Law 200. And Labor Law 200 is a codification of the common law, and now you're back to proving negligence, okay? So one of the things that I did last month is we kind of created this anatomy of a labor law case, and I've also created now an anatomy of a premises liability case. And I'm going to show you the two, briefly the labor law, and we won't go into it too deeply, but briefly that, and then I'm going to show you how it's similar or different than the premises. So if you take a look at this chart, right, all the chart is showing is that the plaintiff in a labor law case is going to sue the owner and the general contractor, right? And the other thing it's showing in red is the potential insurance that's available, okay? So the owner should have a commercial general liability, that's what CGL stands for, and should have potentially an umbrella policy, that's what UMB stands for. And so the owner should have that type of coverage, and there could be multiple umbrella policies depending upon how big this owner is, or their company is, right? And then the general contractor, same thing, right? They're going to have a CGL and an umbrella policy, and then the subcontractor is going to have CGL should have an umbrella policy. Again, there's a lot of disclaimers coming out in these cases, and some of these policies don't apply, but these are the things that the policies that you should generally be looking for, right? And you're going to see how this is very similar in a minute to the premises liability. So one of the things that I always push is that when you're asking for your insurance disclosures on these cases are just a general premises liability case, you should always, push the parties to give you all of the coverage, because usually what happens is the owner is going to tender to the general contractor and they're going to take over the defense. And now you have one lawyer representing the owner and the general contractor, right? And then when they send you those insurance disclosures during your case, 9 out of 10 times, all you're going to get is the general contractor's insurance. Why? Because usually that's the insurance carrier that retained the attorney, and that's the policy that they give the attorney. And that's the policy that the owner is being defended under and the general contractor is being defended under. But you have to keep in mind for your case, if you have a very significant injury case, that you're going to want all of the available coverage, right? So you're going to want to make sure that you go out there and say, hey, wait a minute, you gave me the general contractors, CGL and umbrella, but you didn't give me the owners. Give me that. Okay. And it's something, I mean, we just had that in a case ourselves where we're going through the coverage and plotting it out. And I'm going, wait a minute, we're missing 2 policies here. So as you can see in this particular case also, because it's a labor law case, the plaintiff can't sue the employer directly, right? But even though they can't sue the employer directly, the coverage for the employer is still there to potentially cover the claim. Okay. Now, Michelle, you want to put up the other one, the other chart?
And Rose, if I could jump in with a practice tip.
Yeah.
When you look at your complaint, you want to make sure that you have the policies for every listed party other than the plaintiff, I guess. So if there's a third-party action brought in, if there's multiple defendants named, don't just sit back when you get one policy in response to your demand for insurance, which you should have a thorough one. Rosa gave a whole lecture last year, I think it was, on the Comprehensive Insurance Disclosure Act and what you're entitled to, which is all policies that may cover this. All right. So you are entitled to get not just the disclosure of the amount and the policy number, which is usually what you get, but the actual policy, the claims adjuster's contact information. You must follow up and push and get it for every single named defendant in the case. If not, you're not doing your job. Go ahead, Rose.
Yeah, and one of the other things I'm going to mention is just to jump on what Andrew just said, and it just reminded me, I had a recent case where there was an issue with the insurance, right? And so the client, it's a company, one of their insurance companies was denying or disclaiming coverage, but the attorney had been retained by that company and was defending the client in the case, okay? Just to set the stage. And then when they went to disclose the available insurance, they disclosed one policy that the client had, but they didn't disclose the policy that they disclaimed under. And the client contacted us and said, you know, here's this thing, they want me to sign this, because technically the client is supposed to verify now under the new law, verify the insurance disclosure. And the client sent it to us, and I looked at it and I said, they can't do this. The defense lawyer is not a coverage lawyer and should not be making a coverage determination. The defense lawyer just needs to disclose the possible available coverage. If there are if there are coverage issues, that's a whole other story. But just, I thought that was important to piggyback on what Andrew said. So now let's look at my little tenant premises liability chart here. Very similar and as comical as all these lines are on it. Really the only difference between this and what we talked about last month is that the plaintiff will sue if there's like a subtenant or a tenant. The plaintiff will sue that entity, because if they're negligent, then you're going to go after that entity directly, right? Now, again, as we talked about before, what's going to happen in these cases is the owner is going to tender over to the tenant, right? And they're going to say, hey, we have a lease and you owe us defense and indemnification under that lease, right? So if the tenant's carrier picks up, then again, you're going to want to make sure that you get the coverage that's available for the owner themselves, the umbrella and the commercial general liability. And again, you know, and everyone's tendering to everyone else, as you can see. And generally, again, perfect world, indemnification runs upstream, meaning that the subtenant or the tenant's going to owe indemnification and insurance to the owner. All right. And one of the things I want to just point out is that indemnification and insurance coverage are two totally separate things. And so you shouldn't confuse one with the other. You have to analyze them separately and look at them separately. So when you're looking at a lease, for example, it'll have an indemnification provision, hopefully, and it hopefully will have an insurance procurement provision saying, hey, you got to get coverage tenant for the owner, right? And depending upon the language of those provisions, then maybe the tenant's policy will pick up, right? But sometimes, you know, these leases, it's very important. They really govern, they end up governing what's going to happen with the coverage and obviously with indemnification. And so the phraseology in these leases is very important. And I'm going to talk about that in a minute too. So some of the things that we frequently see, Michelle, you could take this down now. Thank you. One of the things that I frequently see is that for whatever reason, landlords in many cases seem to think they don't need their own insurance because the tenant has insurance, which is furthest from the truth and a fatal mistake. So, you know, if you have a client who's a commercial client and they've got a lease in place, I recommend, and we do this all the time for our clients, we review their leases yearly, we review their policies yearly, and I'll review the tenant's policies yearly to see what is in them. a lot of times what happens is the landlord has the lease and they'll get a certificate of insurance, right? And a certificate of insurance, whether you're talking about construction and labor law and you're talking about premises liability, it's not worth the paper it's written on. It means absolutely nothing. In terms of binding the insurance company, because there are other issues. I mean, maybe the broker did something wrong. That's a different story. But in terms of coverage, the insurance carrier is not bound by what that certificate says. So your clients should be reviewing, having their indemnity provisions reviewed and their insurance policies, the actual policy, and not rely upon the tenant to give a certificate of insurance. I mean, I have a case right now, a very bad case, where that's exactly happened. The tenant gave the client a certificate of insurance, and then he doesn't have any coverage. So, and the client now has no coverage, and they own an asset, they own a building. So it's a problem. So don't rely upon the certificate of insurance. The other thing you want to make sure when you're reviewing the leases is you have a case, right? You're trying to figure out who's responsible, who's on the hook, who's going to pay. What's the language of the indemnification? Because a lot of times the insurance policies will rely upon the contractual language for it to be triggered, right? So just as a really general example, not citing to any specific endorsement, but it'll say, we're going to cover an additional insured, meaning the owner, for any liability arising out of the tenant's responsibility, something to that effect, right? So now you go back to the lease. So what does the lease require, right? Because you're going to refer to something to find out what the tenant and landlord responsibilities are. And what inevitably happens in these landlord-tenant cases is that the carrier for the tenant will deny coverage to the landlord because they'll say, oh, no, the tenant wasn't responsible for that. You landlord, you're responsible. It's a structural issue. That's the landlord's responsibility. And so in a lot of cases, the landlord is left with no insurance. So I'll give you an example. I had another case where, again, the landlord, he thought the tenant would provide the coverage and he didn't need to have liability coverage. I don't know, but who told him that? But these people have been doing, business for years. They've been functioning as landlords for 30 years, 40 years. That's not the way it used to be. Everything was a handshake back then. And that's not how it is now. So he didn't get insurance and the tenant did have insurance. But what happened was he called me, I don't have insurance. What am I going to do? I said, okay, let's tender to the tenant, right? So we did, we tendered to the tenant. The tenant's carrier now says, nope, I'm sorry. It doesn't arise out of our client's responsibility on the lease. So we're not providing you with any coverage, right? So now the client had to hire an attorney to defend, had to hire me to file a lawsuit against the insurance company, right? And now we had to fight with the carrier. Ultimately,
and the plaintiff is sitting there not even knowing if there's going to be any coverage for the accident, thinking, oh, it's a building, there's a tenant, there's got to be coverage, right?
Right. And at the end of the day, even though I know everybody and as plaintiffs, we always say, well, we have a building, we have an asset, so we don't care, but you really do care. You really want to get it resolved within the insurance limits or with the insurance to make it, to resolve it quickly for your client and not to have to, attach an asset and chase an asset, which, is very difficult. So, I think it's important in that one respect to have them.
If you're joining us today via podcast, the first attendance verification code is POD124. That's POD124.
All right, so the other area where I see problems are in clients that have long-term leases, right? So I had a client he's had this lease for 20 years. And he comes to me and suddenly, of course, there's an accident on one of the properties and the tenant has an insurance policy that has an exclusion on it that I'm going to explain in a minute, what's called an action over exclusion, okay? Which are very common now.
An action, what did you say? Action what?
The action over.
Action over. Okay.
exclusion. So what an action over exclusion is, basically, it excludes, and there's many different kinds of action over exclusions, but just in general, it excludes coverage if there's an injury to a worker. All right. And generally, landlords, I find, at least my clients, they're really not even aware of what this means. Like, they don't realize that if they hire somebody to go change out a boiler, or they hire somebody to do some repairs inside of the tenancy, that if somebody is hurt while that's happening, an employee is injured from that work, from that company, that they may have no insurance. Okay. And this happens all the time in the construction litigation context, and these action over exclusions are rampant. They're in many, many, many policies. But it also happens in commercial general liability premises policies. And I have several clients who have this problem. And they aren't aware that they're doing a simple repair on their premises, and they have this. All right.
So an example, Rose, if I could just jump in. So let's say someone owns a building and the awning needs to be replaced. Someone comes over, they call up an awning company, come fix it, replace it. They get on the ladder, they fall, they get badly injured. They say it's because of a crack underneath their ladder. They sue the building, and then the building's insurance company disclaims and says, we don't cover workers. Would that be the scenario?
Exactly. So it's not just limited to construction, which is what a lot of people think. This happens on a regular basis to regular property owners, right? And I've had clients come to me and say, well, I don't understand this. They were supposed to get insurance for this. And when I try to explain to them is, with long-term leases, right, you're not even reviewing these things. The leases were written 20 years ago. And so back then, the policies didn't contain action over exclusions, but now they do. So unfortunately, it's one of those situations where, again, the business owners should have, some kind of a provision where the insurance can be reviewed yearly to make sure that it's compliant. Because, and in particular, this one client that I have, we've made it so that every year he sends me the insurance for himself and for his tenants. And I review it and make sure that these policies don't have these provisions that are going to preclude him from being covered. And, chances are, when you think about it, that's what people are going to get hurt. They're doing work on something. I mean, yeah, somebody could trip on the sidewalk, and that is your general premises liability case. But, when you own a building and you're doing work on the building, these are the things that routinely happen, and there's no coverage. The other area where we see all the time coverage issues in premises liability, and now I'm going to flip to like the homeowner side of things, are where you have suits against a family member who lives with other family members. That's one scenario. And then there's also suits by family members against family members. Okay. And just as a little bit of a backdrop, and then I want Andrew to explain this one case that we had, which was kind of interesting. So under a homeowner's policy, you need to be a resident and a relative of the named insured in order to be an insured under the policy. So your kids, if you have a policy of insurance in your house, your kids are resident relatives, right? And there's a slew of case law around what resident means. I mean, relative's kind of straightforward, but there are some cases about what's a relative, right? If it's an aunt or a cousin, or is that a relative, So it generally, the case law revolves around the resident issue. Do they live there, right? And so, we had a case, and this is Andrew, if you want to talk about our Sykes case.
Yeah, so we had a really interesting case where we were approached to review a potential product liability case. And I'll try and be quick with the fact scenario. A young man is at his father's house visiting. He doesn't live there. And he goes he's there regularly, and he goes down and he brings his son. He's got a 2-year-old son or 3-year-old son. And he goes down to the basement where he's got a gym sort of set up, where his father does. And there's a leg press machine where you sit in it, sort of recline on your back, you put your feet up and you press it up. And the way that you set it is there's different sort of holes on the side where you put the pins in for where you want the press and the weights to be. And what happened was while he's there, he's keeping an eye on his toddler while he's working out, right? And the toddler comes walking over and sticks his finger in one of the holes, and the press comes down and cuts off his finger. So we get contacted by the father who says, I think, is there a product liability case here? This is pretty dangerous product. So I said, send me some pictures of the leg press, and right on the sides are big stickers. Warning, keep small children away. Warning, keep fingers out of holes, all that sort of stuff. And after looking at it and with the warnings, I said, look, you're going nowhere on a product liability case here. Then I started to think, I wonder if the grandfather who owns the house has coverage, homeowners coverage. Would homeowners cover something like this? So what do I do? But I ask Rosa, what do you think? She goes, it might be. You have to look at the policy because sometimes they'll exclude family members or relatives or residents, but let's see. So we get a copy of the grandfather's policy, and there's some language, and it's not necessarily really clear one way or another. But after speaking with Rosa, we said, we think it might apply, and there's $1 million of coverage. So let's give it a shot. So we file suit on behalf of the child, against his grandfather. And we asked the family, we need to make sure this is all above board. If it's allowed, it's allowed. But are you all right with being sued? It would be your policy to cover your grandchild's injury. They said, sure. So sure enough, we get underway with litigation. We bring it in federal court. And they didn't even push the disclaimer. They didn't disclaim. They said, well, we think it might be this. We think it might be a relative. We're not sure. They asked for some information. And we filed suit, we got underway, and we settled it for a very substantial amount and got it resolved. And that was an example of how, by thinking outside of the box, instead of just saying, no, it's not a product case, we're sorry, and you start thinking, well, who could another potential tortfeasor be? And what other potential coverage may apply? And we looked into it, and we got the policy, and we were able to change this young child's life and set him up for the future. So that's an idea where you're going to have instances where a family member either could be very tight, a spouse, a child, a grandchild, a cousin, and that's going to depend on the policy and some other things. But we are seeing more and more cases where people are injured on a family member's property or in their house. And the question is whether or not you can bring those cases. And more likely than not, I believe you can, but it's going to depend on the policies, which you would need to really review and be prepared to get into a declaratory judgment situation to determine whether coverage is there or not. But keep in mind that even just doing that, bringing the case and being willing to fight that fight on a declaratory judgment, that sometimes is enough to generate settlement talks. They may say, listen, we don't want to spend all this money litigating it. If at the end of the day, there's a potential chance we're going to have to cover this, maybe we can just resolve this while there's still some uncertainty.
Yeah, and the issue of whether or not, so what the carriers look at is they're looking at whether or not this person, now let's just say, I'm going to give you another example. In that case that Andrew talked about, it was the grandchild making a claim against the grandfather, right? The grandfather's policy. And so, there were liability issues there. And I believe, Andrew, if I'm remembering this correctly, it was that the father of the child, he actually lived with the dad. He would visit the father periodically. I think I remember that being the case. And so the issue was he covered? Because he was the negligent one. He was the one that was doing this thing where the kid was sitting right next to him and he's using his weights. So, and the father did reside temporarily with the dad. And so he was covered as an insured, where the child didn't. The child resided with the mother.
And that was important because in the policy, it said an insured cannot be the beneficiary of a claim against another insured. So if it was the son suing the grandfather, he'd be out of luck, the son suing his father, because they're both insureds and insureds can't cover each other. But with Rosa's help, we're able to establish factually that the grandchild, the injured party, was not an insured under the policy. So was able to bring the claim. It was either we did that, or it might have been that, correct me if I'm wrong, Rosa, that the infant who was injured, his mom was actually the plaintiff, and she was not an insured clearly. So by her bringing the claim on behalf of him, she was the plaintiff and she had the right because she was also not an insured.
I mean, we were concerned about all these issues, and I think at the end it didn't turn out to be, it didn't turn out that way. They covered it, and rightfully so, because the kid did not live there at the house. And the father just brought him there for the day. And so that was successful. But we have another case where, now this is another issue that comes up all the time. So sometimes you'll have these multifamily residences, and sometimes it's actually multifamily, like they're zoned multifamily, but a lot of times it's not, right? It's just people have these homes and they have them separated, and mom and dad live upstairs, and then like son lives downstairs, but there's separate kitchens and all this other kind of stuff.
Separate entrances.
Right. So we have a case, and this happens frequently, where the daughter is residing in an apartment on the ground floor, and she gets injured, right, due to a defect in a stairwell coming up from the apartment. The carrier does her investigation, and they claim that she's a resident, she's a resident of the same household as her parents, and they disclaim coverage. Okay. We, obviously we're a plaintiff in this suit. So this is just like a side note. As a plaintiff, you do not have a direct right of action against the insurance company for a defendant unless you have an unsatisfied judgment that's been unsatisfied for 30 days. That's the general rule, except where the reason for the disclaimer is late notice. Okay. So that's one of the things. So as a plaintiff, you can't just file a lawsuit against a defendant's insurance company. So in this particular case, what we ended up doing was we ended up getting a confession of judgment from the parents because there was a defect in the staircase. And he said, fine, you can go after my insurance company now. And then we started the DJ action. And so we currently have the DJ action pending. Now, again, when you're looking at these issues of residents of the household, it's very fact specific, and the case was all over the place. So I recommend, if you have this issue, you really need to dig in. The carriers have their investigators who are going to get information from the clients. And a lot of times they're getting this information, right after the accident happens, and the clients don't know what's covered and not covered. I'm talking about the insureds, and they're just, answering the questions, and truthfully, hopefully, and the carrier may not get the proper information in terms of whether or not this individual is really residing with. In our case, she was not residing with. She had her own apartment. She got her own mail separately, her own kitchen. Everything was separate. She paid rent. So it was a separate apartment, but they didn't see it that way. So now we're in the middle of litigation. So that's some of the areas that I see on premises liability. And I think
the moral, if I can jump in, Rosa, just quickly, the moral of this story, so to speak, is that don't give up. Don't just be like, oh, they're family members, or oh, they live together, oh, this won't be it. Do your due diligence, get the policies, see what the facts are, see what's going on, because there may be something there, and it would be a shame for you and a potential client not to avail yourselves of a defendant with coverage.
Yeah. So with the last, like 10 minutes that we have, I just want to go over, a couple of things, two things. One is duty to defend versus duty to indemnify, right? So if you have a client and they have, let's just say you're a landlord, and you think you're owed coverage under the tenant's insurance policy. Generally, the complaint in one of these cases that I've seen, a premises liability case like this, will say the landlord's negligent. It'll say the tenant's negligent, the injury arose out of the tenant's negligence. Technically, depending upon what the insurance policy says, and I'd have to read the insurance policy, that should be enough to trigger the tenant's insurance company to defend the landlord, right? So, because what we look at in New York is we look at the four corners of the complaint. That's what they call it. And basically, if there's a possibility of coverage, the way that the complaint is phrased, then they owe a duty to defend. But that doesn't mean that they're going to ultimately owe indemnification, meaning to pay for the damages, right? Again, in my case, the example that we had earlier, the dispute was whether or not the defect was a structural defect and whether my client as a landlord was responsible for that or whether the tenant was responsible for that. But just by virtue of the fact that it's a question and that the lease was not 100% clear and that the landlord saying, no, that's the tenant, and that the complaint said the landlord was negligent because of the tenant's actions, that carrier should have defended our client. And then what they could do, or what they should do, in my opinion, is they should issue a reservation of rights and say, okay, we're going to defend you, but we may not indemnify you because if it's determined that that the tenant was not responsible for this. And they should defend it. And then ultimately they may pay, indemnify, ultimately they may not. That's the way generally it should go, but it doesn't always go like that. In my experience, it's actually the opposite. They'll just disclaim. In which case your client as a landlord is left with no insurance. And is going to have to file a DJ to get the coverage, unfortunately. But that is generally. Now, the other issue just in this reservation of rights context I want to bring out, and I brought this up in other seminars that we've given. If there's a reservation of rights against your client may be entitled to independent counsel at the expense of the insurance company. So what happens is when they issue these reservations of rights, they'll say, okay, here's defense counsel who's going to represent you. And just like in any other case, if you had insurance, the insurance carrier chooses who the defense counsel is. But in some circumstances, and I won't get into it here, but in some circumstances, there's a conflict of interest between the carrier and the insured because they may not cover it. And in that situation, your client would be entitled to independent counsel. So if you're representing a landlord, you could represent the landlord with the carrier paying your fee. Okay, it's just important to know.
Rosa, can I jump in for a second?
Yeah, please. Yeah.
So it's really important to look at this from the plaintiff side and the defense side. So if you're a plaintiff in this situation, right, where you've got a tenant and a landlord, and in your complaint, you've named both, if you just get the lawyers, you get a CC'd on a reservation of rights, you're like, okay, I'm not sure what that really means, but they're in it. You stick it in your file. You're like, oh, they hired a defense firm. They're a big firm. There must be coverage here. Why would they be paying for defense? And we're in good shape. And then you could be litigating this case. And then like right before the eve of trial, when you're like, what's going on? Why aren't we settling this case? Defense counsel could turn to you and be like, there's no coverage here. We are hired under reservation of rights. So as a plaintiff, you've got to roll up your sleeves and get to the bottom of what's going on here and maybe jump in and know what your situation is. Because if the landlord doesn't have coverage and the tenant's disclaiming, even though they have counsel, don't think that you've got a recoverable case here where you can get your client compensated. Now, same thing on the defense side. If you're being appointed counsel, don't think you're all set. And if you're the landlord getting counsel appointed, that can be yanked from you any moment. So you really need to roll up your sleeves and get into it early on to make sure that you're being protected. Because just the fact that they've assigned counsel doesn't really mean you're being protected. So you really need to, you start seeing a disclaimer letter, a reservation of rights letter, any of this stuff come across your desk, whether you're defense counsel or plaintiff's counsel, you've got to jump into action. Don't just stick it in the file. Don't be like, oh, it's not my problem.
Yeah. So for example, like we'll have other plaintiff firms that we work with that when they get those, they'll send those over and just say, can you go take a look at this? Let me know what you think. Because sometimes they really don't mean much. And then sometimes they do. And that's when you gotta really kick in. The other thing I wanted to mention, just as another important point in these cases, as a plaintiff under Insurance Law 3420, you have a right to place the carriers of the defendants on notice, right? Where there's a distinction. If a co-defendant does it, like I say, a co-defendant places the carrier of another co-defendant on notice, it doesn't have the same force and effect. And so as a plaintiff, you have that independent right. And you should pursue it. You should pursue your insurance disclosures and get the coverage and then do that. Because otherwise, you really should never rely on the defendants to notify all the carriers because you just don't know if they're doing it. And we just had this happen to us on a case, right? They're going along, they're defending it under, they think they have a self-insured retention, which they do, they have a self-insured retention. They're defending under the self-insured retention. So they're telling us, that's what we think. And all of a sudden it's getting towards the end of the case when we find out they never notified the carrier, right? Now, luckily in that case, we had notified the carrier early on in the case. And so we're in a battle with that. They're saying they never received it. We know they received it. But as a plaintiff, you really should be pursuing the coverage and not sitting back and thinking that somebody else is taking care of this for you, because they're not. And then the last thing, which we only have 5 minutes left, so I'm just going to jump right to it, is you probably heard about disclaimers of coverage, right? 30 days to disclaim coverage. They should be disclaiming coverage in 30 days. And that is really only a rule of thumb. It is not a black and white. It's not 30 days doesn't come from a statute. It's decisional law that says what is reasonable and not reasonable, right? So one of the first things that I look at when I get a disclaimer of coverage in a case is I look at that right away. Is it a disclaimer, which I can explain in 2 minutes? And if it is a disclaimer, quote unquote disclaimer, did they do it in a reasonable amount of time? And a lot of times we don't know. You don't know if they did, because if the insured, you're a plaintiff now, if the insured placed the carrier on notice, you don't know when that happened. You're the plaintiff. So sometimes it takes legwork on the backside by us to figure out and to get in touch with the defendants themselves, the defendant's broker, the defendant's lawyer. And sometimes we're doing this all in the background while these cases come in, or I get a reservation of rights. Now, I'm allowed to talk to the attorney for the defendant. I'm allowed to talk to the defendant. If it's a disclaimer, there's no attorney. So we kind of work, our magic, so to speak, to try and figure out what happened here. Was there a timely notice? Is it a legitimate disclaimer of coverage? Because if it isn't, then we have to advise our client. If it's a legitimate disclaimer, we have to tell the client there may not be any coverage here. And we have an obligation to do that. And the client may want to cut their losses, or the client may want to continue. So these are just some of the important points. And I think, just the last note with the last 2 minutes is that when you're looking at disclaimers, I put a checklist in the materials. I also put those charts in the materials, by the way, so they're in there if you want to print them out. I put a little checklist of when a disclaimer is required, because they're not always required. So if something is outside the scope of coverage, like let's just say, for example, it's outside the policy period, the courts don't require that 30-day disclaimer. I mean, they may still have to deny it or disclaim it. There's other avenues we can pursue, but as a general rule, if it's outside the scope of coverage, that 30 days doesn't apply. 30 days doesn't apply to property damage cases. It only applies to bodily injury cases. So these are kind of all important things. And then, last but not least, I don't know if I mentioned it earlier. If you, take what I do is with every case when it comes in, I print out the caption. And I'm old fashioned, so sometimes I actually do physically print it out. And I print out the caption, and then next to the name of every party, I put the insurance policies. Because, sometimes when you have these cases that there's 5 different parties, you're forgetting who the carriers are. And sometimes you don't even have the carrier information. And that will allow you to pursue your insurance disclosures better, and also to keep track and how much coverage they have. So, yeah, so that's, that's just a little practice tip that I'm going to give you on this. And And I think that's in the time period that we have. But if you need anything, please schedule a one-on-one. You can, oh, there it is. You can scan there. And you can also just reach out to me at Arfini at Smiley Law. And we can talk if you have any questions.
So I will moderate the questions and I'll throw them out to Rosa, or I may take a few on my own, depending. So I think the first one might be one that I can take, and it's from Michael. He's saying, quote, in recent dog bite cases and exclusions appearing and policies for dog attacks if there's a prior bite, in both claim against an owner and a landlord. As soon as proof of a prior bite is produced, the disclaimer letter is served by the carrier. Any suggestion on how to deal with this? I'll actually let you take this, Rosa.
Sure. Well, again, this sounds to me like there's an issue of the timing. When did the carrier know about the prior dog bite? It just said as soon as proof of a prior bite is produced, a disclaimer letter is served. I mean, if they didn't have knowledge of the prior bite, how could they disclaim it? So honestly, probably, it may be a timely disclaimer unless they had some evidence that there was a prior bite. I'm actually curious to see that exclusion because I have never seen that. I've seen exclusions where it's just dogs, you can't have dogs, period, in certain properties. But that's interesting because that really kind of piggybacks on liability, right? Because that's the basis of liability is the prior bite. So it's almost like the two things really go hand in hand. And isn't that an issue to be litigated in the case? So, it may be a premature disclaimer on my part, but, again, I'd have to see it to be, perfectly clear. Yeah.
Yeah, so if you want to get us a copy of that, we'll take a look at the disclaimer policy and share our thoughts with you. All right, Mustafa says a roof facade falls on a passerby, but the building has a lease with a tenant on the ground floor, the supermarket, who is at fault ultimately. If you only sue the owner, is that a problem? Or you must sue the tenant as well? That's the question. Do you have to sue the tenant if you think that the landlord has coverage for it?
Well, it's really an issue of liability. I mean, right? So, I mean, if I was in that situation, I would sue both of them.
I would too.
I wouldn't take any chances. I mean, look, if the roof facade falls on a passerby, that may be the owner's responsibility under the lease. So that's hard to say, but I wouldn't leave the tenant out, depending upon what the lease says. But I certainly would sue both.
Yeah, and you don't know what the fact circumstances were. Suppose the supermarket said, we want to freshen up our look. We want to do a new roof. We want to do new windows in the front. And the landlord said, sure, no problem, but you pay for it. You make sure you have coverage. You indemnify us and everything else. And then if you haven't sued the tenant and it looks like they're the ones who ultimately put this whole thing underway, then you may have a problem. So when in doubt, and if you have a legitimate basis, because I'm not a fan of suing 10 million people. I hate seeing those complaints. I'm not a fan of that. I've discussed that previously. You really need to have a valid basis for naming somebody in a lawsuit. Certainly, this would be a valid basis, and you wouldn't want to miss out on naming both. All right, Michael is asking, is there a way to obtain the policy limits on a premises case prior to suit? Does the Insurance Disclosure Act only apply to after an answer is filed?
Okay, so the Insurance Disclosure Act only applies once a case is in litigation. However, there's an Insurance Law 3420, there's a provision in there that allows a plaintiff to request the policy limits of a policy and for injury cases. So you can request it and they do have to disclose the limits, but they don't have to give you the policy. So that's the difference.
Right. All right. Lewis says the following. Client got stabbed in the chest by a security guard for a New York City bar after forcibly removed from the bar. The security guard's employer insurance carrier is considering disclaiming coverage based on the idea that the guard pled guilty to aggravated assault. However, at the least, shouldn't the carrier be required to stay in the case and defend it if the complaint alleges negligent hiring, training, and supervision?
Yes.
There you
The
go.
carrier, you know, and assault cases are very, very difficult for the carriers to get out of because a lot of times there is an element of negligence, you know, when somebody hurts somebody. So it's, you know, it's whether or not, I think the standard is, it's not just whether the act is intended, but whether the injury was intended for an intentional act exclusion. But if there's a criminal act exclusion in the policy, that might be an issue. So, and this person, so, you know, that might be the problem with that case. If this criminal act, that's a stronger disclaimer.
Yeah. Okay. Next, Don's question. If a certificate of coverage is useless, how does the owner protect their investment when a general contractor or a sub provides this certificate? Are you requesting the policy from each? Is that what you should be doing?
Yes, yes. And I put it in when I talk to the clients and I work on the insurance provisions in their leases with them. We make it required that they produce a copy of the policy on a yearly basis.
Yep. Get the policy, folks. Get the policy. We can't make that clear enough. Do not rely on a disclosure of a policy number, of a policy amount. Get the policy in full and get all of them, and you're entitled to them. So push for it. All right, Susan is saying, are there any specific limitations on the breadth of the immunity that may be granted to a landlord? I'm not sure what that means. And I don't think landlords get any immunity. So it may be a coverage issue that you're asking about. Rosa, if you have
You know,
any.
unless she's talking about like an absentee landlord kind of situation, right? I mean, maybe, I mean, you know, if there's absentee landlord, I know that, you know, they don't have responsibility. But again, that's why you got to bring the tenant in. But yeah, I'm not sure that's what you're referring to.
Yep. All right. Kenneth, how you doing, my friend and fellow co-presenter? He chimed in that, yes, you should ask for the actual policies to the last one as well. So thank you for that. Knocking off some business for us there. All right, Lawrence, and make sure they have action over coverage. Lawrence
Right.
gets extra points for paying attention today.
And it's also, you know, with that action over coverage, one of the things that I find is that it's becoming increasingly difficult for the clients to get that coverage without it. And some of them can't. And I've had landlords who basically, I tell them, look, it's a business decision you're making. And what they've done is they don't have it on their policies. They're also going to pay a gazillion dollars, but they'll get it on the tenant, make sure that the tenant's policy doesn't have the action over coverage. And at least they're saving some money on their policy, but they'll get the coverage if there's an accident.
Chris, I think we just answered that. That's the name of the exclusion. It's called the action over. So we just took care of that. Betty is saying, what if the family member is paying rent and there is proof? I assume you're talking about in multifamily situations. And Rose, I would imagine that that's great. That really helps if you're trying to bring a claim.
Right, that's one of the elements, and there's a lot of elements. And you know, if you take a look at the research, you'll see the cases that talk about this. You know, the more elements you have to support that they are independent, the better.
Alex is asking, isn't there a policy exclusion if the insured signs a confession of judgment, thereby prejudicing the carrier?
Well, the issue is that they disclaimed. So once they've disclaimed, the carrier can't prove that they were prejudiced. I mean, they wipe their hands of the whole thing. At least that's my position on it. So I agree with you. You can't just do that if the carrier is going to defend you. But this is a case where they didn't. They're not defending and they disclaim coverage.
Right. Mary, is Rosa willing to review a property owner's insurance policy? There's several residential buildings, insurance policies, to see if the owner has proper insurance policies without a claim pending as an advisor. Of course.
Yeah, that's what we do. We do that. I do that all the time for my clients.
Yep, we'd be happy. We do that
Yes.
for other law firms, for clients. It's part of our risk and insurance division's work that we constantly are reviewing people's policies, business owners, making sure everything's buttoned up. That's, you know, so many of these things can be dealt with prior, you know, in advance. If people just take a little bit of time and a little bit of money to do it right, it's going to save you a lot of time and money on the back end if you're not buttoned up. All right. So yeah, Mary, just reach out to Rosa. All right. Ooh, there's a lot more to get through. All right, we're trying, folks. We're doing pretty well. All right, John says parents rent out the second house to a daughter and family. Daughter trips on the exterior broken steps. There's no lease. Parents provide all maintenance for the second house. Is there an exclusion for the resident relative under these circumstances?
So it's not an exclusion. Well, no, I'm sorry, it is an exclusion. But the thing is that it just depends on what else is involved here. So the parents, they rent out to the daughter. They may not have a written lease, but does she, does she pay for her electric separate? Does she? It's very dependent. And also, the question is whether or not they reside in the same household. So if you want to do the research on that phrase, so that means like, are they eating dinner together? Are they making dinner together? Are they hanging out in the living room together? I mean, it's a household. So, and the cases are really all over the place, honestly, but you'd have to really get more facts from the client to find out how separate are they really. I mean, is she having dinner with the parents every single night? As her mother making her bed? I mean, her mother doing her laundry. I mean, then it's not necessarily separate.
Right. All right, moving along. Melvin asks, and I don't know what the CPLR section is, Rose, I'll be impressed if you do. What is the role of New York CPLR section 1007 when third-party practice allowed in landlord and tenant liability related defense actions? Do you know what that's referring to?
No,
I don't. So I don't either. Sorry, Melvin. I don't know about section 1007. If anybody else has any thoughts, please chime in on that. All right. Zach, how long must black ice be present to satisfy notice? That's not a coverage one, so I'll take that. It's tough. Black ice cases are really hard. I mean, it's almost like the definition of black ice is you don't see it, right? So somehow you have to establish that, if you can establish it was present for a long enough time that a reasonable person would have seen it there or slipped on it, I think it's going to be heavily fact-based. I don't think there's a clear answer, but black ice cases are tough. It usually happens right around the time of precipitation or shortly thereafter. So what we'll do in those cases is sort of look into the history. So let's say it's an apartment building and the apartment building has a lot of tenants and they have a maintenance company, and the maintenance personnel you are able to establish in discovery is supposed to go out and salt the sidewalk. And they salt it whenever there's word that there's a snowstorm coming, and that if they did if they did salt the sidewalk, there wouldn't be any ice on it. So you could kind of work backwards if you find out that that was their requirement and part of their maintenance duties. The fact that the black ice developed, really their only defense would be, well, it happened between the hours of midnight and 4 a.m. We were gonna salt it that morning. They'll probably be off the hook there. So it'll be fact specific in my opinion.
If you're joining us by podcast, the second attendance verification code is POD 421. Again, that's POD 421.
All right. Gina, we are now handling our first slip and fall case against Walmart. Congratulations. What strategies or tips could you provide? Well, Walmart's going to have defense firms. They're going to have insurance coverage. It's not going to be any different, though, than any other premise case or supermarket cases. Again, you got to look into notice. The good thing is, I'd imagine Walmart has cameras everywhere. I'd immediately demand footage, send a preservation letter, get your investigators out there, see what you can do to establish things. Otherwise, it's just going to be like any other premise case.
So I
All
just
right.
want to jump in one second. Andrew, I was like, CPLR 1007, I have to know which one. That's just a third party action CPLR
Okay.
set. Allowing it. So it's just like any other case. You're allowed to, implead a defendant as long as you have a viable cause of action against them, and particularly a contractual one at that. If it's a landlord tenant, but you can feel free to give me a call after this if you'd like to discuss it further.
Yeah, and you can get discovery as a plaintiff from the third party. So you're entitled to ask them for their policies and everything else. All right. Keith, in the suit against the grandfather regarding the exercise machine, what were the causes of action? What do we have in there? I think we had negligent supervision. was a main one, right? Not monitoring this child, allowing a toddler in an area that's not supervised and could be dangerous. Failing to warn, not notifying the father to not let the child near the machine, not notifying the child. So I'm pretty sure if you have a similar case, Keith, just shoot me an email or reach out to me. I'm happy to dig out our complaint because I'm pretty sure we threw the kitchen sink in there on that one and it was enough. All right, Ryan is asking, in a slip and fall case involving a storm in progress, not good for the plaintiff, good for the defendant, specifically one in which the plaintiff plainly stated that it was actively snowing outside and they saw 1 to 1.5 feet of snow on the stairs leading from the front door to the sidewalk before they tried to walk down the stairs and eventually fell. Can you think of a sufficient strategy to survive a summary judgment motion with a storm in progress defense asserted? Tough case, my friend. Tough case. I don't have any ideas. I don't know how you get around a summary judgment motion when a person says, yeah, I looked out the window, I saw it was an active snowstorm and there was 1.5 feet of snow on the steps and I decided to walk down it anyway and fell. I think you're going to lose on summary judgment. I can't think of any other way unless perhaps the tenant called a maintenance company and said, I need to get out of here. There's an emergency. Per my lease agreement, you're going to keep the steps clear 24/7. And I had no choice but to go out in it because you failed to do it. You got to start thinking outside the box. But unless you have that, I don't know, Rosa, any thoughts on that scenario?
No, I think it's definitely
Tough one. Sorry. John, getting disclaimers on dog bite cases for pit bulls or other vicious breeds, even without a prior bite, are these disclaimers valid?
Again, I want to see what so when you're saying disclaimers, are you meaning a denial of liability or disclaimer of coverage? Because it's two different things. So I would want to see what the exclusion is that because like I said, I have seen policies that exclude coverage if you have certain types of dogs. I have seen that.
And it would be valid, right? I mean, if you get an insurance policy and your homeowner's policy says, we will cover you. However, we will not cover you if you have a pit bull who bites somebody and then you get sued and you have a pit bull who bit somebody. That's straight up contract law. That's going to be valid.
Right. Unless the disclaimer is untimely. So that's the other thing to figure out. But you have to, take a look at that.
All right. Corinne is saying the building has a pizzeria on the first floor and a residential apartment above, but I'm not seeing what the question is. So if you want to type in some more information, that would be helpful. Alana, can you please speak about injury in a building where both the owner and the tenant have no insurance?
That's a tough one. And that happens. I mean, we've cases like that. And it's really a situation where the owner has an asset. Again, we're back to that. And this is the liability question, not coverage, but, the owner does have an asset. And so unfortunately, they may have to pay out of pocket to resolve the case, and there's really no other way around it.
And Alana, here's what you're going to face if you're a plaintiff in this situation. When Rose was talking earlier about how you want to deal with insurance and not assets, there's 423 participants right now. Please chime in if you've ever successfully gone after a defendant, forced the sale of a building to compensate your client. I'd like to see how many people have successfully done that. It can be done. It's rare, super rare. So basically, you have to be willing to go the distance at a risk of getting zero. So you're faced with a scenario like that, Alana, where let's say there's a bad injury. Okay, let's assume it's $1 million injury. Everybody agrees, and there's no coverage, but the landlord owns the building, and maybe the building's worth $500,000. All right, or more or less. You would have to get a verdict or get a judgment. So either a summary judgment and then an inquest and a judgment, or go to trial, spend the money, get a jury verdict, enter your judgment, your bills of costs, everything else. Then you're going to have to execute that judgment against the defendant, against their asset. Now, you're likely going to be second in line to someone else, a mortgage holder, a bank, that's keeping it as a security for loans, whatever it is. But I'm not aware of a situation where you are allowed to go ahead and force the sale easily. It's going to cost a lot of money, and you may not get anywhere at the end of the day.
But
So
I will say one thing though. I know that building owners don't like to have, once you get that judgment on their property, they can't get loans. They can't, so they don't want that. And
yep.
so they unfortunately, maybe there's a way to negotiate with them directly to get them to pay something to your client. And it may be less than what your client would have taken if there was insurance, but in an effort to get it resolved quickly, you might want to do that.
Alana, we're doing that right now. We have a case. It's a building in Manhattan that's worth money, and our client fell, broke her ankle, surgery. We feel we've got good liability. Their insurance company disclaimed, and we were able to review the disclaimer, and it was valid in our opinion. And so they're defending it. They hired a lawyer. They're paying out of pocket. And we're saying, look, we'll settle the case, but they've got to come up with something. Otherwise, we're going to keep going and get a judgment. And, then it becomes a battle of how much are they willing to pay? How much is your client willing to take? How much are you willing to invest in the litigation and the process moving forward?
Mhm.
Okay. Michael, how you doing, my friend? My experience has been that most policies don't cover negligent security at all. Have you seen that,
I
Rosa?
think it depends. Yes, I have seen that, but I think it depends on the kind of policy it is. Again, it just depends on is it a bar that doesn't have then that's just bad coverage. You have to have a coverage for negligent security for a bar. So I think it just depends on what it's insuring, what property it's insuring.
Okay. Ryan, how you doing, my friend? Here's what Ryan has to say. Accident happened 2.5 years ago. The carrier is put on notice immediately and stays involved up until the time of the complaint. The facts of the accident are known by the carrier at the time of the accident. Once the lawsuit is sued out, the insurance carrier denies coverage. Does the defendant have an argument against its carrier that it waived a disclaimer since it waited over 2 years before disclaiming coverage?
Yes, potentially. It depends on what the basis is. So again, if you want to reach out to me, I mean, certainly, if they were placed on notice, they have a time limit to disclaim coverage. But again, it may be in denial. So I'd have to look at, and even 2.5 years is a long time, especially if they've been involved in the case.
Yeah, yeah. Definitely want to take a good hard look at that, Ryan. Happy to help you with that one. All right, Alex, is late notice period longer in a premises case because it is impossible to find the identity of the insurance carrier until much later?
Okay, so from an insurance perspective, they should know who their insurance carrier is, right? So the carrier is going to say late notice. But as a plaintiff, the only way to find it out is, obviously it's going to take you longer. So to a certain respect, there is case law that talks about this. I haven't read it in a long time, but I know that there's case law that talks about, basically whether it was reasonably possible for you to place them on notice and your timing on the notice and whether you, notified them. So it just depends. Again, it depends on what the circumstances are of the case.
All right. Karen or Corinne gave us some more information. Tenant of the pizzeria knowingly purchases and uses illegal pesticide when months-old baby living in the apartment poisoned as a result. Also poisoned with lead in the apartment. The owner's policy has a disclaimer based on the complaint, which referred to, quote, knowing the use and hazard of insecticide. Any better way to plead the facts?
I have to see the policy. I mean, I would like to see the disclaimer. Obviously, you may not have the policy, but I would like to see the disclaimer to see what the language is of that exclusion for the pesticides. Because there may be a way around it like that too.
Okay. Dana is asking, does labor law strict liability sections apply to an owner of a personal residence cutting trees down on his property and a family member gets hurt while doing so? No, I can take that one. So in labor law actions, you have to establish that it's more than a two-family home. So the labor law doesn't apply in New York State to private single-family homes or two-family homes. You got to get to three-family or higher for it to apply, and there has to be construction work going on, renovation work, tree cutting. In the scenario that you described, you do not have a labor law case there, in my opinion. Okay, Alex, which statute did Rosa cite that requires the disclosure of the policy limits, but not the identity of the carrier? I think this was the pre-suit.
It's Insurance Law 3420. I'm just trying to find the subsection for you because it's a pretty long section, but it is Insurance Law 3420, and it is in there someplace. It's one of the subsections. So if you want to just send me an email, I have it up, but I just can't find it at this minute. So
All right, you can look while I'm handling Scott's question. He said that ice cream was on the floor, which caused the visitor at a mall to fall. How long for constructive notice? So my take and experience on that is it's going to have to be practicable. So it would have to be enough time for someone to reasonably discover it, who is in a position or notified of it, to clean it up, and they fail to do so. And that's always hard. That's the burden is on the plaintiff to establish that. So if a client comes to me and says, I fell at the mall on ice cream and I broke my ankle, can I sue the mall? My first question is going to be, well, how do we prove notice? How do we know that there wasn't a little kid walking 10 steps 5 minutes beforehand who dropped the ice cream, and then this person comes and steps and falls? If you think about it, it wouldn't be fair to hold the landlord or the maintenance personnel liable for that. They're gonna be like, no one told us. We can't respond to things that we don't know about. Now, if it had happened in the morning and there's some way you could establish that, maybe through video, or however, it's hard. That's why these cases are very difficult. And you show that it's sitting there for the entire day. And maybe you've even gotten the video, you've got some maintenance people walking by and ignoring it, right? That's the other extreme. Then you would have constructive notice. So that's going to be fact-based. And the proof for those are really hard. You're really going to need to get, in my opinion, some surveillance footage, because you're probably not going to find that little kid to come and testify and say, I dropped my ice cream, in the morning and the accident happened afterwards. So those are tough.
just to answer the question quick, so it's 3420 D1B.
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 Mitchell, you get the last question here. What can you do if a potential target, an example, an insurance broker who failed to procure malpractice coverage, refuses to disclose their liability coverage? They may not have given notice, presumably to reduce the claim history. You need to give notice. Do you have to sue first? If you do, isn't that bolstering a late notice defense?
Yeah, I mean, definitely. It's a loaded question, but you're right. I mean, they refuse to disclose their limits. I mean, technically, if they're in suit, they have to disclose the insurance. And that's something I would bring up. I mean, if you're in litigation with the person, I would make a motion and compel them. They're not the ones that are going to determine coverage or non-coverage. They're required to disclose it under the CPLR.
Well, I'll thank everybody on behalf of Rosa and myself for your patience listening to us. Please don't be shy. Reach out to us, schedule one-on-ones. That's what we like to do. We like to help people. That's what we're here for. Check out the podcast anywhere where you listen to podcasts, Apple, Spotify, Google, all that. It's the Mentor ESQ podcast. You can get CLE credit through the podcast and some cool interview episodes. You can also go to the website. We have all the materials available from all the CLEs, and also, if you need additional resources, out on Amazon are my 2 books on how to successfully litigate a personal injury case and successful trial skills. And all the profits from all of this go to my charitable causes, the Just Hands Foundation, Michael Simmons, Friends of Michael Simmons, and the Water Project. So thank you all for your consideration and have a great holiday. We will see you in 2025. Rose and I will be back on January 8th to talk about everybody's favorite topic, SUM cases.